Well, it's my pleasure to be here today. And again, as Peggy let you know, my name is Brenda Carroll, and I am the Director of Professional Conduct Review here at the college. And I've been in this role for about 18 months now. So by background, I am a registered nurse, and I also have a law degree. So it's a really good mix of experience and skill set for this role. And my presentation to you today is going to go over this general overview of self-regulation and the role of the college. And we'll hone in specifically then on the professional conduct review process. So without any further ado, I guess one of the things that I'm always amazed at is I sort of start this presentation off and said, I'm sure you all, after 2 years of the pandemic, know exactly who this individual is on the screen. However, I suspect that prior to COVID, you had no idea who this person was if I'd flashed up a picture in front of you. And the point of this slide is, don't wait to get to know the College of Nurses until you are in a PCR position, if that unfortunate situation should happen. It's really important you understand the role of the college, what our mandate is, help nurses in the province, and what our sort of function is, and not just sort of, we're the regulator police that send you a letter when somebody complains about something. So with that in mind, with respect to the role of the regulator, we are the regulator. And I think people have a misunderstanding of what the role of a regulator is. The regulator actually works on behalf of the public. So we are here to protect the public interest and ensure that nurses continue to provide safe professional care. Who we are not is we're not a professional association. And I know that's a relatively recent switch in a lot of jurisdictions, and including here, where it used to be the Association of Registered Nurses of Newfoundland and Labrador, and Alberta recently made that same switch away from the word association. Associations are usually groups that act on behalf of nursing to advance the profession and influence policy. So there might be a group of OR nurses, the Association of OR Nurses of Canada, and they sort of look at best practices and they try and lobby for change and expanded scope and things like that. So those are professional associations. The other thing we are not is we are not your union. So we do not get involved in issues as between nurses and an employer as far as things like salary, benefits, or working conditions. So that's the difference. A lot of people, very many people don't understand the role. And I know a lot of times people ask me where I work. I say at the College of Nurses, and they either A, ask me what I teach, or B, say, oh, I have a friend that works for the union. And so there's definitely a distinction. So where does the college get its power to act on behalf of the nurses? And the most powerful piece of authority, and where the rules and our mandate are outlined, is in the Registered Nurses Act of 2008. In addition to that, the Act is supported by the Registered Nurses Regulations. And then we also look towards things like the CNA Code of Ethics, practice standards, and practice guidelines. But right now we're going to really chat about, what happens and what that Registered Nurses Act lays out for the structure and where those regulations come into play. So what is the mandate of the college? Firstly, our mandate is threefold: advance the ethical and professional standards of nursing. Secondly, promote proficiency and competency in our registrants. And lastly, to promote participation in activities that promote health and well-being of the public. And that last little piece is a little bit confusing because that does sound like that association type work, but the registered nurses do, as a college, get involved in matters like looking at practice standards, making sure the scope of nursing is appropriate, and working towards in that realm of bettering and advancing the profession for the public. So how do we do all of this? Well, there's a number of things we do. The first thing, one of the things you may not know we do is we do education program approval. So the schools of nursing in the province submit their curriculum to the college, and we review that curriculum and ensure that the programs are providing the right education for nurses and meeting the educational standards that are expected. In addition, we look after licensure and registration of registered nurses and NPs. And this is probably where most of you have come into contact with college, because when you initially graduate or move to the province, you have to become registered. And then annually, you have to review your license to practice. And that there's the registry piece where we keep track of who's working where in the province. And that's just a matter of being able to track people in case there's incidents, issues, or concerns. And also there's a high level piece of providing data to government agencies when needed. We also oversee the continuing competency program. And all of you, this is under revamp, but all of you to date annually have to keep up to date with your learning and education and submit proof of your continuing competency in the audit if you're selected. So we do oversee that continuing competency program. And lastly, we have our professional conduct review processes. So that's where we're going to come for the rest of my discussion with you today. So what is that professional conduct review? Well, in a nutshell, that's when people complain about nurses. So how many people bring allegations of inappropriate practice or unprofessional practice to the college each year? We've just finished our year end. And so as you can see, this is the trend over the last 5 years of the number of complaint forms that we receive. So this is the number of complaint forms, this green line. So you can see there was a little dip, a low number in 2018, 2019, but we've been steadily increasing with the number of complaints received annually. And that may be part and parcel of a growing workforce. It may be awareness. And it may be public appetite. Not really sure what all the contributing factors to this increase are, but we this year did have the highest number of complaints registered with the college for nurses in Newfoundland and nurse practitioners in Newfoundland and Labrador. The blue bars are the number of registrants, and you will see that the number of registrants is in the last few years relatively steady. And why would the number of complaint forms be higher than the number of registrants? And that would be because we do have registrants that receive more than one allegation. So it might be that they have an allegation at the beginning of the year, and then maybe there's another one midway through the year, or it could be that there's one incident, but we get complaint forms from professional practice, from public, and or patients and things like that. So there may be multiple issues or multiple complaint forms about the same issue. So what do people complain about? Well, for us to get involved in a situation, the complaint must be categorized into one of the 5 buckets or categories of conduct deserving of sanction. And these are defined in the Registered Nurses Act. So there are 5 different buckets: misconduct, incompetence, conduct unbecoming of a registered nurse, incapacity or unfit to practice, and then the last is breach of an act, regulation, or code of ethics. Now, I know a lot of people look at that list and looks like there's a number of synonyms in there. So I'll give you examples of what each of those has been determined to encompass. Misconduct. Misconduct is things like failing to follow special orders of the MOH, failure to communicate appropriately. This would be failure to document appropriately. This is basically you're not conducting yourself in the workplace as you are expected to with respect to standards of practice and practice guidelines. Incompetence is very similar. So incompetence as well would encompass things like medication errors, These are truly clinical issues, usually the incompetence ones, clinical practice concerns. So medication errors, failure to demonstrate critical thinking, those kind of truly clinical practice concerns usually fall in that incompetence bucket. Conduct unbecoming sounds a lot like misconduct. Typically, the way we've defined conduct unbecoming is to encompass conduct that happens outside the workplace, not necessarily outside the building, but certainly outside your professional function as a nurse. So if you get a criminal conviction in the community, there is a provision in the Act that says, as a registered nurse, if you are convicted of a criminal offense, you must report that to the regulator. So, and I get that some of them aren't really related to practice, and this is where sometimes people aren't aware of this. If you get an impaired driving conviction, not just a charge, but an actual conviction, you do need to inform the regulator of that conviction. Most of the reason that occurs is because we want to be mindful if someone has an assault charge or a theft charge, because you do act in a role over a vulnerable population. Privacy breaches would be conduct unbecoming, particularly if someone's accessing information from a home computer, or they're accessing information on their own time, on their break, whatever. So those would be examples of conduct unbecoming. Incapacity and unfit to practice generally revolves around things like impairment due to addictions. So we do unfortunately have registrants who have challenges with addiction issues, and those do get reported to us, and we facilitate and intervene to help mitigate the risks that come with that. The other one would be lack of capacity. Occasionally, we have nurses that stay into the profession either later on in their years or because of some kind of illness or cognitive issue, they are deemed to eventually be losing their capacity, and we have to intervene with respect to that. Breach of Act, regulation, or the code of ethics. So this is a pretty big bucket. This includes a number of things. Practicing without a license or liability protection. So if you forget to renew your license every year and you continue to work 3 or more shifts, there is an allegation process that goes along with that. In addition, failure to remit your continuing competency documents falls into this, because that is part of the regulations under the Registered Nurses Act. So that's the kind of stuff we see. Like, those are just some general examples. There's more information about those definitions of conduct unbecoming and a greater number of examples of what falls into those different categories. And you can find those on our website at CRNNL.ca. So what do we actually see? So this gives you an example of, just a basic pie graph of how much of each of those categories we are seeing. The biggest number of complaints that come in is this group here, the breach of Act, regulations, or a code. And part of the reason for that is almost every other complaint that comes in is also breach of the code of ethics. So a lot of times it'll be a misconduct allegation, and then we will include a breach of the code of ethics as well. The second biggest category is professional misconduct. And again, that's those situations maybe where, there's an argument in the workplace where someone uses profanity language with a coworker, or gets physical with a coworker, fail to document things. Those become part of the misconduct piece. But the theft of narcotics would fall into the professional misconduct piece. The next biggest group is incompetence. And those are those purely clinical issues where you have individuals who, people's practice are just in question. They're not taking the vital signs. They're not doing thorough assessments. They're not able to critically analyze data they're collecting. They're not putting in the right interventions once they see certain symptoms or signs in patients and clients. So that's the incompetence piece. Conduct and becoming is, again, that community behavior, and we do get a number of those complaints each year. Sometimes we get them and they are indicative of other things, like sometimes we'll get a call from a registrant saying they've been convicted of a criminal offense, and in addition to that, they'll acknowledge that they have an addiction challenge that they're trying to work through. And so that's that smallest category of the incapacity or unfit to practice. So who's complaining? That's the other big thing, is who sends in all these complaint forms. Certainly by far the biggest group of the complaint forms comes in from the employer, and this would be the professional practice groups in each of the health authorities. So when there's issues, incidents, or concerns, those matters that get raised to that professional practice level, practice feels there's been conduct deserving of sanction, which they also have the obligation to let us know if they change an employee's work schedule due to what could be conduct deserving of sanction. So for instance, this year, one of the things we had was a number of nurses who chose not to get vaccinated for COVID when the mandatory employer policy for vaccination came in throughout the province. And because they were unvaccinated, the employers chose, or had as part of the policy, to put them on leave without pay. Well, because they altered their work schedule, they reported that to us. Now, in that instance, we did not choose to file allegations against nurses because there is a freedom of choice with respect to being vaccinated. But they did report to us that they had changed a schedule. So that's the biggest group. There's also this red band here. The second largest number of allegations filed are actually filed by the Director of Professional Conduct Review through my office. And a lot of times those are the ones that come to our attention directly through college processes, things like working without your license, failing to remit your CCP, or if we get wind in the media that there's a criminal situation where someone's been convicted and they haven't reported to us, we will do that. If we get an employer that sends in a complaint form, the first thing we do is send it out to the registrant by registered mail. If they don't answer us, they can get an allegation for failing to respond to the regulator. So that's the next biggest bucket, are those process ones that come through our office. And then the next biggest group is where we have colleagues complaining. So this might be a nurse practitioner concerned about an RN's practice. It could be a nurse complaining about another nurse. And there is a duty to report in the legislation. So if you have direct and observable evidence that another nurse or nurse practitioner has engaged in conduct deserving of sanction, you have an obligation as a registrant to bring that to the college's attention. So that's a lot of this situation here, where folks have, under that duty to report, brought matters to our attention. The smallest group of the concerns and complaints are brought to us from the public. So this would be either patients or families on the patient's behalf with the patient's consent. Sometimes it could be a bystander, it could be an observer, but if they have direct observable evidence of something they believe to have been conduct deserving of sanction, then any individual can file a complaint here with the college. So again, this is just talking about that duty to report. And again, it's if you have direct observable knowledge, you do have a duty to bring that to our attention. And you can do one of two things. You can contact the CRNNL by phone, email, or pop into the office. That's certainly possible. You should always have a discussion with your employer prior to bringing the matter so that they're not blindsided by it. And then you can go to the website, and there is a complaint form that's available on the CRNNL.ca website. and it's a PDF form. You can fill it out. You do have to print it off, sign it, and then send it back into us, either scanned, faxed, or even a picture of each page attached to an email is fine for my purpose. But we do need to receive them in writing, and they do need to be signed by the person bringing the matter forward. So what happens when an allegation comes in the door? So as I said, that complaint form comes in and we triage all of our complaints. So we look at them and we have a little rating scale where we sort of assess the risk that comes with the allegation that's on the page. Sometimes we get matters brought to our attention that, you know, aren't necessarily conduct we would desire of our registrants, but they might not meet that threshold of actual conduct deserving of sanction. And most of the time, these would be the ones, sometimes they would be brought by public members, and it might be something to the effect of, you know, I was in a merge and the nurse was really rude to me. And, you know, she didn't believe what I had to say, and she didn't answer the bell as quickly as I wanted her to. And so not really necessarily looking like on the face of it being conduct deserving of sanction, but certainly not, you know, what we aspire to do. So in those instances, we have a path that we put them into, which is called our quality assurance path. And we have a professional practice nurse that we give those complaints to, and she will review them. She will reach out to the registrant. She'll have a conversation with the registrant. Tell me what happened. Tell me that, you know, here's the form. Let's chat. And she sort of gathers the information. And if the registrant on the other end of the call says, yeah, you know what, we were really busy. We were slammed in a merge. I'd worked 3 shifts in a row. I was on, 14 hours of a 12-hour shift. We were short staffed. We just had a code in the other room. And yeah, I was short with that patient. And you know what, I really probably should have just taken a breath and dug deep and found that extra bit of patience, but I didn't. Well, then we can do quality assurance, and they basically do a learning moment with the registrant. Sometimes they'll direct them to resources to review, or they'll have them write a reflection paper saying, I realized that this is what was happening, and here's where I went wrong, and here's what I would have done going forward in a similar situation so that I found my best practice to put forth. And so we do put those into that quality assurance. If something goes to quality assurance, this goes on no one's record. No one will ever know that that happened other than myself being able to go into a computer file that says quality assurance, and it has a registrant name and a notation that there was a matter sent to quality assurance. We do not track, like when you get a verification statement to practice in another province, this wouldn't even show up. So this is very, very under the radar. It's just an education piece. It's not considered disciplinary. So it's proactive, and the whole point of that quality assurance piece is to address practice concerns before things slide to a point where someone is not reaching the expectations set by practice standards and falls into a conduct deserving of sanction type situation. So where possible, we do that. And in the last year, this year, we've actually not had any matters referred to QA. However, not up until March 31st, but I have had one in April already for this year that we've referred to QA, and they're moving forward with some education strategies. So what happens if it does? It could go to quality assurance. If it's not appropriate for quality assurance, then it goes into what we call our professional conduct review process. This is a disciplinary process. And so depending on what the verification statement in the other province is seeking, if the question that is asked on a registration in other provinces is, has your license ever been under review? If a complaint comes in and it goes into this bucket, that we would say, yes, there has been a complaint lodged against this individual and it did go into a disciplinary matter. We will then tell them what the outcome of that was if it's completed. So if it was dismissed, that will be noted. So, but even when it goes into that professional conduct review, our first choice is to resolve that matter by alternative dispute resolution. And what I mean by alternative dispute resolution is by interventions that help mitigate the risk. If it's a knowledge gap or a practice gap, then what can we do to work with the registrant to fill that void and ensure they have the knowledge, skills, and ability to go forth and continue to practice in an acceptable standard of care? And these alternative dispute resolutions look like a contract. They typically set out the facts of the situation. They do require that the registrant agrees to the facts and acknowledges that those facts gave rise to action by the nurse that is conduct deserving of sanction. And then we put in some stipulations. So there could be education. Oftentimes there's review of the code of ethics, maybe some online modules. There's modules through the CNA with respect to the code of ethics. There's modules through MUN for jurisprudence and other related topics. Sometimes we have folks review our standards of practice, the Registered Nurses Act, and write a reflection paper. Again, this is what happened. Here's where I misstepped. Here's the standards of practice or the code of ethics that I contravened. And here's what I would do differently going forward. These are not always simple agreements. We can get very complex agreements that include everything from going back to the Center of Nursing Studies and having a competency assessment, following through any recommendations that the center may have, taking a course through the center, or we've had some where they've said, no, this person just really needs to come back and do the entire IEN reentry program. And then there could be practice monitoring. So if there was an issue with clinical practice, it might be go back, do these courses. Once you successfully complete the course, then your manager will agree to monitor your practice for a period of time, submit reports to us saying, yes, the practice meets expectations. If there's an addictions issue, this could include alcohol and drug screening and a letter of fit to return to work prior to going back to work. And once you're back at work, ongoing screening. And we have registrants that have been doing alcohol and drug screening tapering. So it might be every month for a year, every other month for a year, every quarter for a year, every 6 months for a year, and then one last test before they can re-enter the profession. So they are quite variable in what they can look like. And the trick is to make it specific enough to the registrant that we're meeting their personal needs, but making it similar enough that other registrants that have had the same issues or challenges have the same level of work to do as far as mitigation strategies. We don't want to be more onerous with one registrant than the next. And I guess the whole point that I try and make at this point in the presentation is, we're not the nursing police. We have no pleasure in just going out and sending out allegations and running hearings and suspensions and restrictions on licenses and all those things. That's not what we aspire to do. Our goal is really to work with the registrants and build their practice so that we can keep people in the workforce and we can help them overcome any shortcomings or challenges that they're experiencing. So if you ever get a letter from us from a professional conduct review perspective, the most important thing you can do is respond. Based on what you say in the response, we will make an attempt to work with you to resolve this in a way that is agreeable to all parties, that is involves remediation rather than putting it through an adversarial type of process. However, sometimes what happens, we get issues that come to us that are from various sources, and the registrant says, no, you know what, I didn't do that, or that's not what happened, or, you know, I don't believe that was conduct deserving of sanction. And in that instance, those matters, they come in, they don't go to quality assurance, they go down the professional conduct review. We can't do ADR because no one's agreeing on the facts of the situation, or they're not agreeing that it's conduct deserving of sanction. So they go to the Complaints Authorization Committee. Now, the Complaints Authorization Committee is made up of 2 members from the CRNNL Council, at least, and at least 1 public member. And when a matter goes to the Complaints Authorization Committee, initially they will see the complaint form that came in, and they will see the registrant's response. They will look at that, and they are kind of a screening tool. So think of them as, you know, like a preliminary inquiry equivalent on a criminal matter. So they're just looking and saying, okay, on the face of this, if the worst case scenario was true and all of this was true, is this something the college should get involved in? Sometimes we get complaints that are all about people's personal life, and there's something going on out there that we just shouldn't get involved in, and they would dismiss that because that's not within our mandate. I don't, you know, sometimes somebody knows their neighbor is a nurse and they're playing their music too loud on Friday night, and the neighbor's upset because they won't turn it down, so they complain to us. And it's like, well, we're not getting involved in that. So they would do something like that. If it's within the mandate of the college, i.e. there's a risk to the public from a healthcare perspective, then is it within the scope of the nurse? Because sometimes people will complain about a situation, but really the issue they're complaining about was an issue with a physician, or it was an issue with the chief medical health officer's order for visitation. It may not really be something that the nurse had power, authority, or control over, in which case, if it's not within the scope of the nurse practice, it should be dismissed. If it's within the mandate of the college, it's within the scope of practice of the nurse, then they would look at the facts, and they cannot determine credibility or veracity of facts. So they would have to look at all of that information and say, if all of this were true, could this be conduct deserving of sanction? And if they say no, they would dismiss it. If they think yes, then they have a couple of options of what they do. If they're not sure, they can send it to investigation. And we have trained investigators here at the college that will take that complaint, take the response, they'll interview people, they'll get documents from the workplace, they'll patient records if need be. They will conduct a thorough investigation and gather more information to take back to that committee and say, okay, we've got more detail here. Now, what do you want to do with this? At which point they can say, yeah, no, you know what, we're dismissing this. This really looked like one thing. It's something different. We're not getting involved. This isn't, or it doesn't reach that threshold of conduct deserving of sanction. Or they can say, yeah, that's conduct deserving of sanction. And we're going to caution and counsel the registrant. Now, caution and counsels are used in situations where there's really no value in doing a hearing. For instance, if you fail to remit your CCP, or if you fail to renew your license, and I file the complaint, and a registrant responds and says, I don't need my license in this role. I'm not working as a nurse, but you clearly are. Or I don't think I should have to submit CCP because I don't want to. Well, then there's no point going to a hearing. Either the documents were submitted or they weren't, or either you had a license or you didn't. Investigation isn't going to tell us much different, in which case they may say, yes, we're going to find that this conduct is conduct deserving of sanction. We're going to caution you going forward to ensure that you renew your license in a timely way. We're going to counsel you to review the jurisprudence model so you understand the role of the regulator. We're going to understand why it's necessary for you to be registered and carry license and liability insurance. That would be the end of the matter. If it's more complex, and they say, yes, this looks like it could be conduct deserving of sanction, but it's competency-based, completely competency-based. And there's stories about, inability to work equipment or inappropriate administration of medication or failure to assess properly, failure to communicate properly, then that would probably go to a full investigation in front of a disciplinary panel. So when it goes to a hearing, that's like a trial. Everything starts new. Our internal legal counsel would advance the case as the college would have it put forth, and the registrant may or may not have counsel bringing forward their evidence. And we really stay away from a win-lose situation. This isn't about winning and losing. We don't get excited when we have a conviction per se, or a finding of conduct deserving of sanction. It's really about making sure we get to the right outcome. And in some instances, a hearing is a necessary way to come to that determination. Sometimes there are true issues of fact or law that need to be clarified before someone can make a decision as to what that conduct really was and what it amounted to and what its impact was. So that's the options of what happens with our professional conduct review process. And I guess there's a couple of takeaways that I really like to stress with people. Respond to communication from the regulator, no matter what it is. If you get a letter, pick up the phone, make a phone call, send a quick email, something to know that you're engaged. Secondly, make sure the information that you provide in your registration renewal every year is accurate and up to date. And if you move, change jobs, change names, those kinds of things, that you go back and update that information, because that's critically important and one of the duties of a registrant. And the other piece is participate in CCP, do your CCP, remit your CCP. That it's, I know sometimes a CCP feels onerous, but making sure you get that in and responding to it in a timely way. And if you need more time or you don't have quite the right number of hours, submit something. Something's better than nothing. And because if you submit something or call and say, I've been off work, I've been ill, we understand we're human. We're not here to just slap a speeding ticket on someone. We understand that life happens and that people sometimes need a little bit of patience and room to sort of keep on track. And we're very supportive of that. And then my other piece is, if you go on sick leave, mat leave, or any kind of extended leave, and you switch your license to non-practicing, or that leave spans over the renewal period, please make sure that you rectify that before you go back to work, that you have a license in place, that you have liability insurance in place. And that includes, and this is what's happening lately, is because a lot of the orientation when people are coming back, and it's most commonly coming back from mat leave. So someone will go on mat leave in February, they'll miss the renewal period for March, April, and then they come back, say in November, December, and they don't realize that they've missed that renewal period. And then the orientation back to work starts with something online, and they think, oh, well, I'm just sitting in my living room. I don't really need liability insurance or a license to do that, but you do. And so then all of a sudden they go back to work, they've worked a week, and somebody says, oh my goodness, you don't have a current license. And we end up going back and saying, you've worked 2.5 weeks, a week at home doing orientation, a week on the floor, and another 2 or 3 days by the time it got to us without a license. And the fine for working without a license is $100 per day per shift worked. There's a max, and it's 3 times the annual licensure fee. So that's new, that it maxes out at approximately $1,200 to $1,500, but it used to be an unlimited number, and we've had people with $5,000 and $6,000 fines because they've just failed to renew their license in that kind of way. So those are the biggest pitfalls, and we're working, like I say, like we lobbied really hard with the board to change the bylaw here to put a cap on that, working without that unauthorized practice, working without a license or liability insurance fee, because we just felt it was too onerous. So as much as we are here to protect the public, we are, we believe in right touch regulation. There is no good to be served by us just running around doing fishing expeditions so we can slap people with a bunch of allegations. We typically don't impose fines on anybody other than an unauthorized practice. So there's no value. We're not generating revenue like they often think with various other entities that will stop you and give you a ticket. Some people think we're just here to do that. We're not. So that's us. That's PCR. By all means, if you ever have any questions, you can call either the main office number, you can call me directly, or you can always call our practice consultants. If you ever have a question about what you're doing, what someone else is doing, what you should be doing, the practice consultants are there to help you navigate that as well.